Mr. Thompson, you may cross-examine.
Thank you, Your Honor. We have some binders. May we approach the court and the witness and pass out the binders?
Certainly you may do so.
Thank you, Your Honor. Good morning, Professor.
Good morning, Mr. Thompson.
You don't consider yourself an expert in the history of marriage in countries outside the United States, correct?
Since I place a fairly high bar on what is expertise, the answer is yes.
So you're not an expert in the history of marriage outside of the United States?
Not in my own terms, no.
And you are not familiar with the institution of marriage in the most populated countries on the planet, China and India, correct?
I'm somewhat familiar.
Well, let's look at what you said in your deposition in the Iowa case. And that's tab 2 of your witness binder. And I would like to direct your attention to page 55, lines 12 through 14.
Okay. Page 55 is under tab 2, is that right?
Yes.
I see. I need my reading glasses for this. Which page?
55. It's in the upper right-hand corner.
Uh-huh.
And in line 12, you were asked, are you familiar with the institution of marriage in the most populated countries on the planet, China and India? And you answered, no, not really. I mean, no. The consequences of same-sex marriage is an impossible question to answer, yes or no.
You're asking me to say yes or no?
I am.
Right. I believe no one predicts the future that accurately.
And you're not an expert on marriage practices in ancient Greece, correct?
I am not an expert on that. I am somewhat familiar with it.
You think gays and lesbians should have the right to marry, correct?
I have come to that view from my research and study of the history of marriage, yes.
And you feel that you're somewhat between a neutral party and an advocate, correct?
I would call myself not an advocate, but someone who has come to a personal opinion as a result of my historical research and study of this marriage study of this matter of the history of marriage for quite a number of years now.
Let's see what you said during your Iowa deposition. The next page, page 59, top of the page, lines 1 through 4. You said, so I feel I'm somewhat between a neutral party and an advocate in that I feel I'm led by my particular historical expertise to feel that this is the direction. Now, you've put in amicus briefs and signed on to amicus briefs in New York, New Jersey, Washington State. Is that correct?
Historian's briefs, that is right.
And you weren't compensated for your work in those cases, were you?
I was not.
Okay. And you volunteered your time because you viewed this as an important civil rights issue, correct?
I volunteered my time because I think it's very important for historians to contribute to public policy discussions.
I'd like to direct your attention to tab 4 of your binder, and this is the Alternatives to Marriage Project. It's the annual report, 2002, and I'd like to direct your attention to page 13. It's the upper right-hand column. It lists donors to this organization, and it lists a Nancy Cott. Is that you? Did you contribute to the Alternatives to Marriage Project?
It's possible. I don't recall. It's possible.
Okay. Let's turn to page 4 of this report, to the mission statements of the Alternatives to Marriage Project, and it states that this organization advocates for equality and fairness for unmarried people, including people who choose not to marry, cannot marry, or live together before marriage. And you support that mission, don't you?
I do.
And in the third sentence of that paragraph, it states, we believe that marriage is only one of many acceptable family forms, and that society should recognize and support healthy relationships in all their diversity. And you support that mission statement, don't you?
I do.
And a polyamorous family is one in which there are 3 or more adults who are in the family group. Is that correct?
I don't know. At the time I signed the statement, I had never heard the term polyamory.
Have you heard it since?
I have heard it since.
What is your understanding of polyamory?
My understanding happens to come from an article that was in the Boston Globe about a week ago. And that was really my education on what it is. And apparently it's a network of people who are in multiple but stable relationships.
All right, let's turn to page 6 of this annual report, to the final bullet point on the page, which reads, and this was written, of course, between before the Supreme Judicial Court of Massachusetts had ruled, so it's a little dated, but it said, Same-sex couples are denied the right to marry in every state. Others are also unable to marry, including those in relationships of more than 2 people. And so, is it your understanding, and do you support the concept, that rights and benefits should be extended to polyamorous families?
No.
Did you support it at the time when you gave money to this organization?
I wasn't aware of it. I knew the couple, the heterosexual couple who founded the organization. They had started it around the time I was publishing my book. And they were mainly interested, and their organization started to give credit to those heterosexuals who wanted to live in stable unions without marrying. And I think the right to marry should be accompanied by an emphasis that one does not have to marry if one doesn't want to. And it was from that angle that I supported this young heterosexual couple who had been pressured by their families to marry, and they didn't want to enter the institution.
And turning to page 6 in your binder, this is the affirmation of family diversity. It's part of the Alternatives to Marriage project. And turning to the 3rd page in your binder behind tab 6, do you see a second line that says, Nancy Cott, History and American Studies, Yale University?
It's not in my binder, no. I see the view signatures here, but I don't see any names.
Not in my binder either, counsel.
Okay, well, maybe we can pull that up on a screen. But regardless, do you recall this document and having signed on to it?
I do.
You do?
I do.
Okay, and you supported the contents of this document, or you wouldn't have signed it?
Yes. That all healthy families should be supported by social views, yes.
Okay, and you shared the concern that was referenced at the end of the first paragraph. What worries us is the mistaken notion that marriage is the only acceptable relationship or family structure. You supported that view?
Yes, I did.
And you think couples should keep a skeptical stance on marriage, correct?
I don't think I've ever made that point.
Well...
Maybe I did. It's possible I said that somewhere in passing.
All right, let's refresh your recollection. Turning to behind tab 3. This is an interview that you provided with a Priscilla Yeaman. Do you remember this interview?
Vaguely.
Okay. And turning to the 4th page of the interview, just one paragraph. It's 7 lines down. Says, I would also say couples should keep a skeptical stance on marriage. Did you believe that at the time you made that statement?
I can't really recall, and this, I never had an opportunity to check the transcript of the interview before she put it up on the web, so really I can't confirm whether or not I said that at the time.
The public authorities are very interested in making sure that as few people as possible are assigned to public sources of funds for their support, correct? Yes or no?
I think that tends to be the case, yes.
Throughout American history, legislatures and courts, in other words, the public apparatus in general, has been very, very interested in making sure that dependent children will be supported by their parents. Yes or no?
That has definitely been a motivation of state authorities, yes.
And one of the purposes of marriage today is to assign providers to care for dependents, including children, and to limit the public's liability to care for the vulnerable, correct?
Yes.
And one of the purposes that marriage has served over this country's history is to create stable families, correct?
Yes, that's fair.
Another purpose that marriage has served over this country's history is to assign providers to care for dependents, including the very young. Correct?
Yes, you asked me that already.
And one of the purposes of the institution of marriage is to ensure that children are raised by their natural mother and father. Correct?
No, I wouldn't say that.
Another one of the purposes that marriage has served over this country's history is to legitimate children. Correct?
Yes, but as I said, that legitimation function is less important now.
You talked in your direct about laws prohibiting interracial marriage. Isn't it true that those laws required that children of an interracial couple be born out of wedlock?
In effect, it created illegitimate sex out of cross-racial racial relationships, yes.
And illegitimate children, too.
Exactly, yes. Any results in children.
And the laws banning interracial marriage created barriers to the establishment of legal ties connecting mother, father, and child, correct?
I wouldn't say they created barriers to legal ties. They simply did not create legal ties or legal obligations the way that legal marriage did.
Now, let's turn to the history of laws prohibiting interracial marriage. The first slaves arrived in this country in 1619, correct?
I believe so.
And the first law banning interracial marriage was in 1691 in Virginia, correct?
No, that is not correct.
When was the first law banning interracial marriage in the United States?
Well, it wasn't phrased precisely with the word marriage, but a law was passed in the colonial Chesapeake in 1667 that punished shameful matches, as they said, between free white women and Negroes. And that, so shameful matches those were the words. But it's clear that the intent was to penalize and criminalize marriages.
Now, let's look at the time of the founding of this country in 1789 and at the original 13 states. It's true that New York never has had a law prohibiting interracial marriage, correct?
I can't say I know absolutely for sure, but it's very plausible that it has never had one.
And Pennsylvania has never had a law prohibiting interracial marriage, correct?
Frankly, I don't know this colony by colony.
New Jersey has never had a law prohibiting interracial marriage, correct?
In the entire state's history?
Correct.
Well, I haven't rechecked every state for the purposes of this report, so I can't confirm or disconfirm what you're saying about those 3 states.
So, you have no idea whether the majority of states at the founding of the country did not have a prohibition on interracial marriage?
That is an irrelevant question, really, because...
On redirect, you can give a speech. It's yes or no now.
Okay, fine.
So you don't know whether the majority...
I don't know precisely how many of the original 13 colonies had such laws.
Okay. But it's fair to say that there was never a uniform legal prohibition on interracial marriage throughout the United States, correct?
It is true that there was never a time that a couple could not go to some state and marry across the color line. That's correct.
And bans on marriage across the color lines were measures designed to maintain white supremacy, correct?
They were never seen so at the time they were passed. They were seen so in 1967, but not until then.
Now, I'd like to ask you some questions about the importance of marriage to society. In the Western world, when you look at any new government that has been formed, especially through revolution, one of the first things that is done is the formulation of the marital policy that will accord with this form of government, correct?
First, you confine the witness's testimony to the United States. Now you are going abroad.
Well, I'd be happy to strike all of her testimony about anything outside the United States. That's fine. I appreciate that, Your Honor. I'll focus a little more carefully on the United States. The institution of marriage in the United States requires public affirmation, correct?
Public witness, public license, if that's what you mean, public affirmation.
Public affirmation.
The stamp of the state, yes.
And as the courts consider whether to redefine marriage so that it is no longer the union of one man and one woman, you would agree that this is a very important point to mark in the evolution of marriage, yes or no?
What is a very important point?
As the courts consider whether to redefine marriage so it is no longer the union of one man and one woman, you would agree that this is a very important point to mark in the evolution of marriage, correct?
I think it's an important point, yes.
And although marriage has always been a changing institution, and one could point to earlier watersheds, perhaps there is none quite so explicit as this particular turning point, correct?
Well, one could argue about that.
Well, you remember you gave an interview to NPR after when the Supreme Judicial Court, Supreme of Massachusetts, was poised to rule. Do you recall that in April of 2004?
I don't, in fact.
All right. Well, I'd like to play you an excerpt from that, see if it refreshes your recollection.
Counsel?
We need to switch, I think, the monitor.
It is switched. What are we playing? Is it an admitted exhibit?
It is not an exhibit.
Oh, okay.
Well, Your Honor, before it's played, we would just like to object and ask whether we are going to hear the whole interview. And we request that the entire interview be played as opposed to some excerpt.
As the witness has proven, she's very eloquent and wholesome in her answers. I believe it's a 20-minute interview, but I just want to play it to refresh her recollection. And on redirect, we're happy to give you the link. You can listen to it at break or play the whole thing on redirect if you like.
Let's just see the portion of the interview you're seeking to refresh the witness's recollection with.
Your Honor, if I could just add one more objection. This is something that was not disclosed to us and provided to us. That's why I don't have the link, so
Well, we...
I see. Let's just take this one step at a time. Mr. Thompson, The portion of the interview you wish to show to the witness?
Thank you, Your Honor. Okay, now I think we're ready to go.
We better start at the beginning. Let's start at the beginning with the volume so that everybody can hear it, including the witness, most importantly.
Thank you, Your Honor. All right. Does that refresh? That was you.
I'm going to object. That sounded like a good sentence. I would like to hear the next answer.
Counsel, go ahead.
Professor, was that you? Was that your voice that we just played?
Yes.
And did it refresh your recollection that you had done an NPR interview?
Yes.
Okay. And you agree with the statement you made there, which is one could point to earlier watersheds, but perhaps none quite so explicit as this particular turning point. Do you agree with that statement?
As I said there, perhaps, and that was how I responded to you, that one could argue about this, but it's arguably a highly distinctive turning point.
As a historian, you do not assume that progress is the rule of history, correct?
That's correct.
Marriage is a very complex institution, correct?
Indeed.
There is a long ongoing series of arguments among historians, competing theories about how we find the causes of any major phenomena, correct?
Yes.
Some historians prefer to weight ideas, correct?
Yes. True.
Others prefer to weight economic factors, correct?
Yes.
Some weigh pure contingency of how things occur, correct?
I give it more weight, yes.
But to you, the most reasonable historical explanation gives some weight to all of these factors so that none of them operates solely on its own, correct?
Yes.
I'd like to turn your attention to tab 9 in your witness binder. This is DIX 1434. It's a law review article from the Virginia Law Review entitled, "We Will Get What We Asked For, Why Legalizing Gay and Lesbian Marriage Will Not Dismantle the Legal Structure of Gender in Every Marriage." It's authored by Nancy D. Polikoff. The UVA Law Review is a well-regarded publication.
I can't confirm or disconfirm that. I assume so, but I don't really know.
And Nancy Polikoff is openly gay and an advocate for gay rights. Is that correct?
I don't know.
She's a professor at American University. Do you know that?
I'm not familiar with her.
Okay. I'd like to turn your attention to page 1536, to the second full paragraph, which reads, "The only argument that has ever tempted me to support efforts to obtain lesbian and gay marriage is the contention that marriages between two men or two women would inherently transform the institution of marriage for all people. Is it true that there are some people who subscribe to the view that Professor Polikoff has articulated?"
Certainly she does, or thinks there is.
Your Honor, we would move the admission of DIX 1434.
Objection, Your Honor. Irrelevant, written by another person. I don't see what bearing it has. The witness said she was not familiar with either the author or the article.
Your Honor, this goes to one of our contentions that we have spoken to before about legislative facts and the Ninth Circuit's ruling in Marshall versus Sawyer, in which they said legislative facts relate to public policy or questions of law. And the Supreme Court, from Brown versus Board of Education to Roe versus Wade to Grutter to Lawrence, and every one of these big-ticket cases has looked at precisely these types of law review articles for the truth of the matter asserted. And we maintain that all of this evidence, just as they wanted to move an entire book into the record, that we are entitled to put into the record in this court case these types of articles and publications that pertain on a key issue, which is, what are the consequences, potentially, of same-sex marriage? And, yes.
Well, the court can take judicial notice of what's published in law reviews, and I can certainly do that. This is a law review, however, written by another individual. The witness has stated that she's not familiar with either the article or the author, so I'll certainly take judicial notice of it. It can be included in the record if you like. The record is as it is.
Thank you, Your Honor, and that's all we're asking for.
Fine.
We appreciate that.
All right. That's going to be, we better have it marked. Previously marked?
It is marked, yes, Your Honor.
As exhibit?
DIX 1434.
1434. All right, very well.
And we'd like to turn your attention to the next tab, which is DIX 1020. And this is an article in the Chapman Journal of Law and Policy. It's dated 2008-2009 by a Jeffrey Redding. Are you familiar with Professor Redding?
I have never heard of him.
Well, he taught at Harvard and Yale, so I thought perhaps you had overlapped. But he's now at the University of St. Louis Law School. I'd like to direct your attention to page 7 of this article, to the paragraph. It's the third full paragraph from the bottom, and it reads, the gay and lesbian civil rights movement's insistence that marriage is the proper province of secular states instead of churches and temples, and its insistence that marriage can incorporate fertile same-sex couples just as readily as it can sterile opposite-sex couples, as a further testament to this movement's deep-seated desire to challenge the conventional meaning of words and concepts. Do you agree that allowing same-sex marriage would challenge the conventional meaning of marriage?
I believe it would amplify the conventional meaning of marriage.
Your Honor, we would ask the court to take judicial notice of DIX 1020.
I beg your pardon?
Turning to the next tab in your binder, Professor, which is DIX 1033. And this is a book entitled All Our Families, New Policies for a New Century, published by the Oxford University Press. It's a pretty prestigious press, is it not?
Yes, it is.
And turning to the fourth page of your binder, which is page 1. It has a 144 at the bottom. Shows that this is an article by Judith Stacy entitled Gay and Lesbian Families Queer Like Us. Professor Stacy is a professor of sociology at NYU. Is that right?
I know she is a professor of sociology. I'm not sure where she teaches right now.
She's a supporter of gay and lesbian rights. Is that right?
I don't know.
Turning to page 155 of this document, she states at the top of the page in the first full paragraph, despite the paucity of mainstream political enthusiasm for legalizing gay marriage, there are good reasons to believe that gays and lesbians will eventually win this right and to support their struggle to do so. Legitimizing gay and lesbian marriages would promote a democratic, pluralist expansion of the meaning, practice, and politics of family life in the United States, helping to supplant the destructive sanctity of the family with respect for diverse and vibrant families. Do you agree with Professor Stacy?
Your Honor, I'm going to object again. This is
I beg your pardon. I beg your pardon, what?
Well, I'm going to object. This is simply an argument from an article that does not have anything to do with Professor Cott.
I think it's appropriate for the counsel to place before the witness propositions that have been, well, factual proposition of this kind that have been asserted by individuals who have expressed views on the subject, and ask whether or not she agrees or disagrees with the statement. And I think that is what counsel's doing. And I think it's an appropriate form of examination. Very well. Proceed, Mr. Thompson.
Thank you, Your Honor. And we'd ask the court to take judicial notice of DIX 1033.
Very well.
Professor, turning to the next tab in your binder, which is tab 12, and this is entitled Ethics.
I'm not sure that you've got an answer to the question with respect to 1033, Mr. Thompson.
Do you agree with Professor Stacy's position?
The sentence that begins legitimizing gay and lesbian marriages, is that what you were asking about on page 155?
Yes, the one that will supplant the destructive sanctity of the family.
This is a statement of her opinion, and I think that it's a plausible line of reasoning, but it's a prediction, and so I'm really rather neutral on it.
Okay. Well, let's turn to tab 12, which is entitled Ethics in the Public Domain, Essays in the Morality of Law and Politics by Joseph Raz. And Professor Raz is a prominent philosopher. Is that right?
I really do not know.
This was published by the Oxford University Press. Do you see that at the bottom of the first page?
Clarendon Press in Oxford, yes.
And turning to your attention to page 23 of this article, let me know when you're there.
Okay.
And the first full paragraph, the last two sentences read, When people demand recognition of gay marriages, they usually mean to demand access to an existing good. In fact, they also ask for the transformation of that good, for there can be no doubt that the recognition of gay marriages will affect as great a transformation in the nature of marriage as that from polygamists to monogamists or from arranged to unarranged marriage. Do you agree with that statement?
I do not.
Your Honor, we ask the court to take judicial notice of DIX 1444.
Very well.
Professor, I'd like you to turn to your next tab in the binder, which is an article by E.J. Graff entitled Retying the Knot in the Nation, and it's DIX 1445. And do you know E.J. Graff?
I have been acquainted with her briefly in the past.
She's at Brandeis University, is that right?
I don't know. I knew her 12, 14 years ago, and it's when she was not at Brandeis, but I don't know where she is now.
When was she, or where was she when you knew her, if you can recall?
She was a journalist trying to write a book.
In turning to the first sentence of this, it says, "The right wing gets it. Same-sex marriage is a breathtakingly subversive idea." Do you agree with that statement?
No.
All right, Your Honor, we ask the court to take judicial notice of DIX 1445.
Very well.
And E.J. Graff is a supporter of the rights of gays and lesbians. Is that correct?
I believe so. I'm not current with her thinking.
You don't have any views on what are the factors that have affected the divorce rate in Massachusetts since same-sex marriage was legalized, correct?
Incorrect.
All right. Let's look at your deposition, page 199. It's behind tab 1. Are you there, Professor?
I'm sorry. What
This is the
page?
deposition in Iowa or the deposition here?
Sorry, Your Honor. This is the one in this case, which is behind tab 1. I put it to the in the witness binder as well. So I was behind tab 2 in the deposition, and the deposition in this case is behind tab 1.
I beg your pardon. Thank you very much. 199?
Yes, Your Honor. And Professor, do you see on line 5 where I asked...
I'm sorry, what page?
199.
199, okay.
On line 5, I asked you, question, what are the factors that have affected divorce rates in Massachusetts over the last 5 years, in your opinion? Objection, objection, calls for speculation, vague, beyond the scope of this report. Answer. I don't have any views on what are the factors that have affected the divorce rate in Massachusetts. I raised this in the report mainly because the reports I was rebutting seem to connect frequency of divorce to in a group of negative factors affecting current social life that they think a same-sex marriage would contribute further to. And so I mention that not as a result of the fact that there is same-sex marriage, but just as a concomitant phenomenon that is worthy of notice. You gave that testimony?
I did. I could clarify the difference between what I responded to you verbally and what is said here, but I can refrain from that as well.
I would like to ask you to turn to tab 17 in your binder, which is DIX 1028. It's an article by Monte Stewart entitled Marriage Facts. And I would like you, Professor, to turn to page 327, the first full paragraph. It says, a fundamental purpose of marriage, then, is to situate heterosexual passion within a social institution that will, to the largest extent practical, assure that the consequences of procreative passion, namely children, begin and continue life with adequate private welfare. Although the immediate objects of the protective aspects of this private welfare purpose are the child and the often vulnerable mother, society itself is the ultimate beneficiary. Do you agree that society itself is the ultimate beneficiary of marriage?
I think that's a very difficult question to answer, yes or no to, without really giving my complete opinion. The question is posed in such a way that I can't really answer it honestly, yes or no.
Your Honor, we would ask the court to take judicial notice of DIX 1028.
Very well. You were reading from page?
327, Your Honor.
Thank you.
Yes, sir. Professor, I'd like to direct your attention to tab 18 in your binder, which is DIX 1475. It's an article that appeared on September 19th, 2008, in the Los Angeles Times by our expert in this case, David Blankenhorn. He starts by saying, I'm a liberal Democrat, and I do not favor same-sex marriage. Do those positions sound contradictory? To me, they fit together. And then turning to the second to last paragraph of this article, he states, here is my reasoning. I reject homophobia and I believe in the equal dignity of gay and lesbian love because I also believe with all my heart in the right of the child to the mother and father who made her. I believe that we, as a society, should seek to maintain and to strengthen the only human institution, marriage, that is specifically intended to safeguard that right and make it real for our children. Professor, is there any other social institution in this country as important to children as marriage?
I think families are important to children. They do not have to be marital families. They often are. I think families are important to children. They do not have to be marital families. They often are. But I can't agree with the approach of Blankenhorn's statements here, which imply that the biological link between parents and children is a necessary foundation of marriage and why it's good for society.
And do you think the biological connection between parents and children is irrelevant to the social well-being of children?
No, I do not think it's irrelevant.
Okay.
I just don't think it's comprehensive in describing what is good for children.
Now, I asked you whether you thought there was a social institution in this country as important to children as marriage, and you answered, well, their families are important. Do you consider families a social institution?
Yes, I do.
Okay, and you would like to direct your attention back, I apologize for flipping around, but to tab 16 for a moment, which is from the CDC. I should have said, Your Honor, I ask that you take judicial notice of DIX 1475.
That'll be fine.
Thank you, Your Honor.
I think the same is for 1028.
Thank you, Your Honor.
May I ask Judge Walker?
All right. I think this would be a good time for a break.
Yeah, I would like to have a break, please, Your Honor. Thank you.
That's not a bad idea. I suspect you're not the only one, Professor.
Thank you.
All right. Sorry for the interruption, counsel. Why don't we take until 10:30, then we will resume with further cross-examination of this witness.
Thank you.
John, this indicates a witness is coming to the stand, and we're continuing this. Well, it says, as this witness is coming to the stand and she's sitting here, how did you want to do that?
As she is, so we need you to get up and walk back, kind of settle back into the chair, is that right?
Well, it describes her as walking to the stand, so, or on her way to the stand.
Well, why don't you just stand up and cheat it a little bit, sort of.
Cheat it this way?
Don't move, just stay right where your chair is, but sort of set yourself down slowly while he's doing that.
Okay.
Spend about 10 seconds doing it. So
Okay.
Okay? And action.
Before we begin, as this witness is coming to the stand, let me advise counsel that we are organizing all of the comments that have been received with respect to broadcasting or webcasting the proceedings. They're in the jury room. There are thousands of them. I don't know how to make them part of the record. I will do that. Some more, of course, are coming in today. They're going to be available for your inspection. I appreciate the suggestions you have on how we may handle them. There are quite a number. So I invite you to inspect them, give your advice as to what we're to do with them, all right? They're not quite ready now, but they'll probably be ready, I would imagine, about the time we take our lunch and break. And you can wait until the end of the day, whatever your pleasure is. All right, Mr. Thompson.
Thank you, Your Honor. Professor, I'd like to direct your attention to tab 16 in your binder, and this is a document from the CDC website from 2004 entitled Assistive Reproductive Technology, which is the first sentence of the document is, the shorthand is ART. And then if you turn to the second page, in the second full sentence, it says, approximately 1% of U.S. infants born in 2004 were conceived through art. Professor, is it your understanding that 99% of all children born in the United States are born of as a result of a procreative act between a man and a woman and not through ART?
These are not statistics that I've looked into at all.
Your Honor, we would ask the court to take judicial notice of DIX 1049.
Very well.
Professor, turning to tab 19, I guess before we get there, let me ask you, do you agree population growth is no longer necessarily seen as so desirable?
Where?
In the United States.
Not as so desirable as it was 2 centuries ago, yes. That I believe is true.
Okay. And directing your attention to the second page behind tab 19, this is the document entitled Low Fertility, Can Governments Make a Difference? By a gentleman who is at the United Nations, dated April 2nd, 2004. It's DIX 1046. And on the second page, in the second full paragraph, it states, a growing number of countries view their low birth rates with the resulting population decline and aging to be a serious crisis, jeopardizing the basic foundations of the nation and threatening its survival. Economic growth and vitality, defense and pensions and health care for the elderly, for example, are all areas of major concern. Professor, do you know whether it's true that in the United States the birth rate is barely at the replacement rate?
I think it's approximately at the replacement rate. But of course, in the United States, immigration has always been a great source of our population growth. We have not relied strictly on reproduction.
Illegal immigration?
No, immigration that has been legal.
Ah, I see.
Immigration that has been encouraged and legal through our history.
Okay. And the birth rate has declined significantly from about 3.5 in the 1960s to about 2.1 today. Is that correct?
I haven't reviewed these statistics recently. That sounds like it could be right, but I can't confirm.
Your Honor, we'd like to ask the court to take judicial notice of DIX 1046.
Very well.
Professor, I would like to ask you to turn your attention to tab 20, and this is an interview with Jonathan Rauch. Mr. Rauch is a prominent supporter of gay rights, is he not?
I really don't know.
Okay. We would, and this is DIX 1035. I would like to direct your attention to the third page of this document, and in particular to the paragraph that's the fourth full paragraph, and it says, marriage is not like voting, something the government just gives you at the stroke of a pen by fiat. Marriage must be a community institution to have its full power, which is to make couples actually closer. It actually fortifies and not just ratifies relationships. Your marriage has to be recognized by your community, your friends, your family, your kids' teachers, your co-workers, all of the people around you as a marriage with all the expectations and social support that goes with that. The law can't give you that. Is Mr. Rauch right that the law can't give you the full power of marriage without the community support?
I have maintained through my work that law and society work in a dynamic relationship in the institution of marriage.
Your Honor, we would ask the court to take judicial notice of DIX 1035.
Very well.
I'd like to switch gears. Professor, to talk about marriage and gender and then marriage in religion. First, marriage uniquely and powerfully influences the way differences between the sexes are conveyed and symbolized. Correct?
I believe that has been true through most of our history, yes.
So far as marriage is a public institution, it is the vehicle through which the apparatus of state can shape the gender order, correct?
Yes.
The whole system of attribution and meaning we call gender relies on, and to a great extent, derives from the structuring provided by marriage, correct?
I wrote that.
And you agree with it?
I do.
Okay. And gender matters. That is, it matters that human beings do not appear as neuter individuals, correct?
Yes.
Notions of gender are not constant, but are specific to time and place, correct?
Yes, I think what we attribute to gender specificity definitely is changing over time.
But the gender binary of masculine and feminine is a basic classification in human thinking and appears in human usage in every culture, correct?
Yes.
We can't really think about human beings without implicitly seeing them in gendered form, correct?
Yes.
Now, let's turn to the role of religion and its relationship to marriage in the United States. You said during direct that civil law has been supreme in the United States. Do you remember that?
Invalidating marriages, yes.
From the founding of the United States to the present day, assumptions about the importance of marriage and its appropriate form have been deeply implanted in public policy, correct?
Yes.
Public authorities in the United States expected monogamy on a Christian model to prevail, correct?
In the past, yes.
And it did, correct?
Yes, yes.
A commitment to monogamous marriage on a Christian model was lodged deep in American political theory, correct?
Yes.
The great majority of colonists believed in basic tenets of Christian monogamy, correct?
Yes.
In the history of this country, both the church and the state have regulated marriage in the sense of instilling people with conscience about what are the appropriate behaviors in marriage, correct?
Yes.
Monogamy on a Christian model prevailed in part because of widespread Christian faith, correct?
Yes.
The particular form of monogamous marriage that is supposed to be lifelong and involves sexual faithfulness between the partners and economic mutual support, that form of marriage arose first as a result of Christianity, correct?
I think that's a historical finding, yes, since in the I think that's a historical finding, yes. Since in the many ancient worlds, most everybody else was polygamous.
Maybe you could keep your voice up, it would be helpful.
Yes.
And one of the distinctive things about Jesus Christ and his apostles' teachings was to pursue a single partner in marriage and not multiple partners, correct?
I know very little about Jesus Christ and his apostles.
Well, you seem to know a little bit more during your deposition. Let's look at page 61 of your deposition. It's behind tab 1.
Page reference, counsel?
Page 61, line 5, Your Honor. And you said, Professor, when I asked you, question, what do you mean by Christian monogamy? Answer. Well, if we look back to the era of the origin of Christianity, which originated, of course, among Jews, Jews were apparently not at that time monogamous. Polygamy was accepted. And one of the distinctive things about Jesus Christ or his apostles' teachings was to pursue a single partner in marriage and not multiple partners. You stand by that testimony, right?
I do. And I was using Jesus Christ or his apostles as a stand-in for the notion that this was a notion that began with Christianity. Not that it was enforceable initially, but it was an innovation. This is what I meant to imply here.
The generation that founded the United States of America in 1789 subscribed to the basic tenets of Christian monogamy, correct?
Yes, but again, I want to make it clear, since you're repeating my words outside of the larger context, that I'm using Christian monogamy there simply to emphasize monogamy, not to point to any other tenets of Christianity that might have been embraced or not embraced.
Are you saying there's a difference between Christian monogamy and some other form of monogamy?
No, I'm simply saying that monogamy in world history is attributable, so far as I'm aware, to Christian precepts.
The pre-Christian societies did not either require monogamy or impose standards of monogamy? Is that what you're saying?
As far as I'm aware, in the history of our own civilizations, that pre-Christian and certainly the early Middle Eastern arenas where Christianity arose, those areas were not restricted to the practice of monogamy. Right.
You are talking about the Western world, I assume?
Well, if we think of Western civilization and the Judeo-Christian ethic, that is broadly what characterizes our Western civilization. Christianity was what introduced a restriction to a single partner for life as the marital regime.
And, Professor, one of the basic tenets of Christian monogamy was that marriage was between a man and a woman, correct?
That was assumed, yes.
And to this day, large segments of Americans accept the Christian conception of sexual fidelity in marriage, correct?
Yes. I do think the notion of sexual fidelity in marriage goes beyond Christianity. But yes, you could put it. I would agree with it the way you put it.
In 1789, there were laws that prohibited brothers from marrying sisters, correct?
Probably, yes. There have typically been restrictions on close familial association for marriage.
And this law reflected a biblical tenet, correct?
I can't say what it arose from. It could have arisen equally from the common law.
Well, I'd like to direct your attention to your deposition, page 136, line 25.
Okay. 136, you said?
136, Professor. And I asked you, question, what was the purpose that the prohibition on brothers marrying sisters, what purpose was served by that law? Various objections. Answer, yeah, I can't really comment on the purpose. I don't know the intentions, the purposeful intentions of the legislatures. Question, do you know what the objective is of such laws? Objection, asked and answered, calls for speculation. Answer, what was your question? The objective? Answer, oh, the objective, to stop people from marrying close members of their family clearly. Question, well, that's tautological, but why wouldn't you have that objective? This is Baxter. Objection, calls for speculation beyond the purpose of the report. Answer, well, I would simply say that this was a biblical tenet and that there were prohibited degrees of marriage, and while the biblical prohibited degrees are very extensive and, interestingly, accordingly to a scholar of father-daughter incest, do not prevent the father from marrying his daughter. Do you stand by your testimony?
Well, as I said there were prescriptions and limits listed biblically. Well, as I said there were prescriptions and limits listed biblically about that, but I don't say here that it was clearly the ground from which those legislative rulings arose. As I go on to say there, I mentioned the common law. Frankly, I think there were multiple bases for the assumption that close members of families should. This was a restriction that the legislature thought was appropriate.
Massachusetts, Puritan religious values strongly infused the English tradition. Yes or no?
Certainly, in colonial Massachusetts.
And Puritan ideology demanded fidelity of both partners, correct?
Yes.
From the 16th century through the 18th, Puritan reformers advocated chastity before marriage and fidelity after for men as well as women, correct?
Did I say reformers? Are you reading my testimony or what?
I don't have to tell you where you said it.
Well, there weren't Puritan reformers. They were Puritan from the beginning. Puritans definitively believed in chastity before marriage and fidelity within it. That's clear.
There were differences between Puritan theory and canon law, correct?
Puritans were radical Protestants. They did not believe in the Catholic teachings.
You are opening the door to the witness's testimony outside the United States.
That's true. The 15th century Puritans, I would concede. 16th century Puritans. She did write an article on the 16th century Puritans.
No, I did not.
Oh, okay. Well, I
have never dealt with the Puritans before the 17th century.
Let's look at tab 24 of your binder, which is an article that you wrote 34 years ago, and it's called Divorce and the Changing Status of Women in 18th Century Massachusetts. And let's turn to page 600. And in the second sentence, you said, from the 16th century through the 18th, Puritan reformers attacked the double standard by advocating chastity before marriage and dealt after for men as well as women. Does that...
I'm sorry, what page and what line are you on?
600, second full sentence.
Okay, well, yeah, I'm actually talking about Puritans in England because there weren't any Puritans in Massachusetts in the 16th century. Yeah, well, it's a general comment, right. It's hardly an article about the Puritans in the 16th century, probably half of one line, a 30-page article.
Well, all right, let's take, you would concede that there are differences between Puritan theory and canon law in 18th century Massachusetts, correct?
Particularly with regard to divorce, which was the subject of this article.
And under canon law, desertion was not even grounds for separate bed and board unless it was combined with cruelty. Is that correct?
Gosh, Mr. Thompson, I haven't worked on this since the mid-1970s. I have to refresh my own memory about these matters.
That would be fine. Let's Let's do that together. Turn to page 608, if you would. And you wrote, and we can look at this together. I'll just read it, and you can let me know if you stand by this or whether your research has changed or your thinking on this. We're on page 608, fourth line down. In Puritan theory, desertion warranted divorce. Under canon law, on the contrary, desertion was not even grounds for separate bed and board unless it was combined with cruelty. Excepting the Fier and Fletcher cases, the governor and council acted as though canon law controlled their decisions on desertion. Does that reflect or refresh your recollection that there were instances in which, in Massachusetts, the governor acted as though canon law were controlling?
I'm afraid that you misinterpret my comment there to mean that I literally thought they were following canon law. This was simply an artful way of saying they did not grant divorces on the basis of desertion unless cruelty accompanied it. The intent, of course, I took this from another secondary source, Howard's Matrimonial Institutions. But my point was simply that they were enforcing a stricter standard for separation from bed and board. It didn't mean they were reading canon law and following it because they were canon law specialists.
Well, in turning to the first sentence of the next paragraph, where you say canon law rather than Puritan precept appears to have guided the decisions in cruelty cases as well.
I guess so. I guess I thought so then from the research that I was doing.
And you stand by that, correct?
I can't redo the research on the stand here, so I have no reason to think that what I said there was mistaken. Although the authorities may have changed, I was citing a book, Howard's Matrimonial Institution, that was written quite a while before that, I think in the earliest 20th century. It was a summary of various colonial laws on divorce. Since the 1970s, a lot more work has been done on colonial divorce, and it's not an issue that I have returned to in my research in a detailed way. So I can't say with absolute certainty that in my scholarly opinion, this is still correct, because I haven't done the detailed research that would enable me to affirm that with great confidence.
At the time of the founding, there was a broadly shared understanding of the essentials of the institution of marriage, correct?
Broadly shared, what was the word?
At the time of the founding, there was a broadly shared understanding of the essentials of the institution of marriage.
Yes, I agree.
The most important was the unity of husband and wife, correct?
Yes, by unity, I meant the doctrine of coverture as I was discussing earlier.
In the 19th century, the Christian religious background of marriage was unquestionably present and prominent, correct?
In definitions of marriage and in common understandings of marriage, yes.
The Christian religious background of marriage was adopted in and filtered through legislation, correct?
That is correct, if you understand me to mean that Christian background in the very basic sense of its being monogamous, ideally lifelong and entailing sexual fidelity, yes.
And by the end of the 19th century, there was an alliance between national authority and Christian monogamous morality, settled firmly in place. Is that correct?
Well, I made that comment with respect to the long campaign that federal authorities took against polygamy as it was being practiced in Utah by the Mormons. The single standard that the national authorities wanted to enforce was that of monogamy, and they had also respected it, and they had also supported it with respect to trying to support the marriages of emancipated slaves in the immediate post-Civil War period.
In the general sense, the social meaning of marriage did not greatly change from 1789 to 1868, correct?
Correct.
There was actually a lot of legal change in the 15 years after the Civil War, correct?
With respect to the laws barring marriage across the color line, yes, there was a lot of change.
And there was challenges to the prohibitions on marriages between blacks and whites in those years, correct?
Yes, on the basis of contractual freedom of the parties to marry.
And some of those challenges were successful, at least temporarily, correct?
Very briefly, in states that were controlled by black legislators.
In the 19th century, many Americans engaged in informal marriages, correct?
That is true.
And pregnancy or childbirth was the signal for a couple to consider themselves married, correct?
Not always, sometimes.
Well, let's look at public vows. Your book, which has been admitted, page 31. It appears behind tab 31 in your binder.
Page 31, you said?
Page 31, and it's the last paragraph, and it reads in part, informal practices continued as white immigrants fanned out to the south and west. Marriage frequently followed up a sexual relationship between a man and a woman. That may be a typo. Is that a typo in your book?
Yeah, yes, I think you are right.
Okay. Between a man and a woman proving fruitful rather than preceding it. Pregnancy or childbirth was the signal for a couple to consider themselves married. You believed that when you wrote those words, didn't you?
Well, as I said, frequently, yes. This part of the sentence that follows, the colon, it also incorporates that frequently adverse. I'm saying, yes, it often was, not.
One recent change in marriage has been the emergence of covenant marriage in certain states, correct?
I'm aware that it exists.
Do you know how many states have covenant marriages?
I believe it's 2.
Which states?
Louisiana and Arkansas, I think.
Any others?
I'm not sure.
And covenant marriage represents a change in the institution of marriage in Louisiana and Arkansas, correct?
I'm not, my understanding was that it provided an alternative sort of marriage to what had been available before covenant was authorized, an additional form of marriage.
And in that sense, it's a change to the institution of marriage to give couples that option, correct?
I really hadn't thought about how much of a change it is. It seemed to me that covenant marriage was more of a restriction that the couple placed upon themselves by deciding for that option rather than the standard option.
What is covenant marriage?
As I understand it, I think the couple pledges never to divorce, but they pledge never to divorce. Is that what it is?
You are the expert.
Well, no. I mean, this is something that's happened in just the past few years that I think it hadn't even happened when I wrote my book, and I never really followed up on it since I didn't see it as a major, I don't know. I just didn't follow up on it. So my sense was that it was harder to get out of a covenant marriage than a standard marriage. And that was what the states had done, provide an option for spouses to say, I want to join this even firmer commitment.
And then the state would enforce that decision, correct?
Well, I assume so, and making it harder for them to divorce if that, I don't know what the specific provisions of covenant marriage are or whether there are any punitive measures of enforcement exactly. I don't know how it's enforced.
The legislation that inspired covenant marriage in Louisiana reflected Christian moral principles. Is that right?
I don't know.
Now, you've reviewed the congressional testimony surrounding the Defense of Marriage Act in connection with writing your book. Is that right?
Not all of it, but a bunch of it, yes.
And congressional debate on the Defense of Marriage Act reiterated long-lived official insistence on traditional marriage as a necessary pillar of the nation, correct?
Yes, many of the proponents of the Defense of Marriage Act did.
Did any of the proponents of the Defense of Marriage Act explain their support for the legislation by reference to their religious convictions?
I don't recall.
You've read Edmund Burke's Reflection on the French Revolution, haven't you?
If I did, it was an awfully long time ago.
Do you know whether you read it or not, do you know that one of the things that Edmund Burke emphasized was a respect for tradition in that work?
I really can't say.
Okay. Do you know whether any of the supporters of the Defense of Marriage Act supported the legislation because of a respect for tradition?
I assume they did. I think that could be inferred.
Did you find evidence in the historical record suggesting that each and every supporter of the Defense of Marriage Act did so because of moral disapproval of gays or lesbians?
I don't know.
In the United States, a state has never prevented a man who is homosexually oriented from marrying a woman who herself is homosexually oriented, correct?
That's correct, so far as I know.
And it's definitely happened that a gay man has married a lesbian, correct?
It has happened.
And so in that sense, sexual orientation is not literally what the law is prescribing in marriage, correct?
Object, Your Honor. Calls for a legal conclusion.
Objection overruled.
Well, the man and the woman were able to marry, so that's all I can say.
Well, let's look at what you said during your Iowa deposition. Tab 2, page 52.
Okay. My Iowa deposition is which tab?
Tab 2.
Somehow I'm only getting tab 35. I must be reversed. Tab 2, page what?
52.
Page 52, okay.
So, if we start at line 13, you were asked, question. If you take sexual orientation out of the equation, then can you think of any reason the state may not want to permit two heterosexual men to marry each other? Answer. Let me just answer your question in another way to illustrate the point I was making about how that I was being literal, and that the state has never prevented a man who is actually homosexually oriented from marrying a woman who herself is homosexually oriented. That is, that has definitely happened, that a gay man has married a lesbian. The state has never prevented that. So, in that sense, sexual orientation is not literally what the law is prescribing in marriage. And you stand by that testimony, correct?
I do.
Okay, now, let's turn to the history of California and marriage. And when did California become a state?
1851, 1850 or 1851, somewhere in there. I think the first Constitution was 51, but I think the state may have been admitted the year before.
In California, in 1851, it was simply assumed that marriage would be between a man and a woman, correct?
I would say so.
And the overwhelming reason why it was assumed was because marriage had long been practiced in that form, correct?
Yes.
And coverture was a creation of the English common law, correct?
That's right.
California laws. California's law in 1851 were not derived from English common law, correct?
The laws of domestic relations, you mean specifically?
Yes.
They were certainly influenced by the civil law, but common law preconceptions and practices about marital roles were incorporated into that. They were not absent from California domestic relation law despite its civil law lineage.
In those common law states that maintained coverture, coverture was a bargain in which each spouse had a very important role that the state enforced, correct?
Yes.
Coverture would not have existed as long as it did were not a bargain that was seen by those who participated in it as reciprocal, as having something in it for both parties, correct?
Correct.
While coverture was in place, there were no statutes that ever said that only the husband can work and the wife can't, correct?
What do you mean by work? Work for pay?
Well, let's take work for pay. There was never a law that said a woman couldn't work for pay?
That's correct, but under coverture, her wages would go to her husband. She wouldn't own them.
Under coverture, a woman's personal and real property, whether acquired before or after the marriage, immediately became the property of her husband, correct?
Yes.
But that was never the case in California, correct?
Under community property, the wife retained title to her property, but the husband was, upon the marriage, the manager of that property, and that had the right to dispose of it and make the decisions. So that the asymmetry of marital roles was still very much a part of the California community property system.
By the time California became a state, coverture had already been significantly broken into by married women's property laws in various states, correct?
Significantly, but not in such a way as to eviscerate by any means the institution. It was simply that in many states by 1850, although not that many by 1850, I was more by 1860, married women had formal title to their property, but all of the other elements of coverture remained very much in place.
By the time California became a state, coverture had already been, before California became a state, the people of California were governed by Spanish law, correct?
I'm not sure precisely. I assume so. Before 1858, before the war, before 1848 rather, before the war, Mexico had the property, and so I don't know exactly what governed between 1848 and 1850. I guess it was part of U.S. territory.
All right. And just so the record is clear, under civil law, coverture did not exist, correct?
Coverture as such did not, but I don't think we should assume that meant a vast difference in terms of the understanding of marriage as dictating quite different spousal roles, quite asymmetrical spousal roles.
Federal courts had very little role in the dismantling of coverture, correct?
That is correct.
Fairly early in California's history, there were legal acknowledgments that a married woman had the right to keep her own property, correct?
Yes, it was fairly early.
Now, let's talk about the social meaning of marriage, which is a term you used in your book and in your report. When you use the term social meaning of marriage, you're referring to how the public views marriage, correct?
Yes, general societal understanding.
And it's your understanding that there's a very, very high proportion of people who believe that the time to get married is when you want to have children, correct?
I think that's generally true of heterosexual couples, yes.
Is it different for homosexual couples?
I think the question would be more variable for, I mean, I don't have any data since same-sex couples have not been able to marry, why it is that they make the choice to marry.
Marriage has evolved into a civil institution through which the state formally recognizes and ennobles individuals' choices to enter into long-term, committed, intimate relationships, correct?
Yes.
But there's no requirement in law that a person who wishes to get married actually intends to have a long-term relationship, correct?
I don't think that marriage licensors inquire into intentions. I think that's accurate.
Mutual love has always been a part of the social meaning of marriage in the United States, correct?
Part of the social meaning, never a precise requisite for entering the institution, but part of a social meaning indeed.
Yeah, but there has never been a legal requirement that people be in love to get married, correct?
Not at all.
Marriage, in your opinion, is a status which implies one's having grown up. Is that correct?
I think that it is part of the social meaning, that it is seen as a mark of adulthood, settling down.
Another social meaning of marriage has been that it is the way to found a household, a living unit that is an economic partnership and that involves a commitment to one's partner, correct?
Yes.
Marriage also has a whole set of romantic meanings for people, correct?
Yes.
And this is broadcast to us all the time in our public culture, correct?
Yes.
So the public culture has an impact on the social meaning of marriage, correct?
Yes, it does.
The social meaning of marriage unquestionably has real-world consequences, correct?
Social meaning exists in the real world, yes.
And just so the record is clear, the social meaning of marriage unquestionably has real-world consequences, yes or no?
Yes.
That is far easier to say than the social meaning of marriage has consequences than to measure the consequences, correct?
I'm going to say yes.
For the generality of people, the social meanings of marriage are highly influential in their own personal views of that institution, correct?
Yes.
One way the social meanings of marriage changes is through actual social practices, correct?
Yes.
Another way the social meaning of marriage changes is through economic transformations, correct?
Economic transformations have a great impact on the social meaning of marriage, yes.
Another way the social meaning of marriage changes is through the ideas and ideology, correct?
These things are all bound up together, yes.
So that's a yes.
Yes.
There are also technological reasons why the social meaning of marriage changes, correct?
Yes, specifically with respect to technology of birth control and other reproductive technologies.
And the law very definitely has an impact on the social meaning of marriage, correct?
Yes.
How a given person thinks about gay marriage, their own or others, it's usually quite affected by quite small-scale factors. How they were brought up, who their friends are, what their religion is, what they have observed in their own personal experience, correct?
Yes.
Now, let me ask you some questions about the state of marriage today. In your opinion, morality has been uncoupled from marriage, correct?
If you're quoting my work there, that was a statement made in a context in which I made the point that whereas in the past adultery and fornication were crimes that were punished by the state, that the state enforced those morally disapproved actions, that in support of marriage and in support of making marriage the only licensed legitimate place where sex could take place. And I think what I was describing in making that claim about morality being uncoupled was that we have a much broader and more flexible set of social mores about sex. Marriage and morality in the past couple of generations, so that state regulations about marriage are no longer. The state enforcement of regulations are no longer principally interested in punishing sex that takes place outside of marriage. Rather, marriage is upheld for other forms of social good and not the seemed to be moral goods that it was principal conveyor of in the past. Morality, particularly with regard to sexual behavior.
Well, the public forgiveness of President Clinton's sexual misadventures can only be understood against the background of a generation's seismic shift in marriage practices, correct?
Yes, I was referring to the fact that the public tended to, at least a majority of the public, did not topple President Clinton from the presidency, even though his infidelities were made public, because I argued The social meaning of marriage had moved toward assuming that spouses themselves are the best ones to decide on what is appropriate behavior within their marriage, so that the public tended to see this as a matter between Hillary Clinton and Bill Clinton, and not a matter that was something the state could judge.
Your Honor, I would request that the witness be instructed to answer the questions yes or no, rather than give these long speeches.
Well, I think you got an answer.
Yeah, I got an answer all right.
Follow up on it, but I don't know that we need to really go into Bill and Hillary Clinton in any great detail.